Welcome everyone to our fourth session of IP4O's monthly webinar series. I'm Vanessa Gutzek, the Legal and Policy Director at Miller International Knowledge, one of the 8 partners of the EU-funded project IP for Open Science. We are delighted to have you all with us today as we delve into a topic at the intersection of academic access and intellectual property law, understanding secondary publication rights, promoting open access through legal tools. Open access continues to be a critical goal for the global research community, and today we'll be looking at secondary publication rights as one of the legal mechanisms that can support this goal. We'll explore how researchers can legally republish their work to reach a broader audience and delve into the legal foundations, national and international relevance, and most importantly, how institutions and individual researchers can effectively implement these rights in practice. It's my pleasure to warmly welcome our speaker for today's webinar, Frantzeska Papadopolou, Professor of Intellectual Property Rights and the head of the IP Law Group of Stockholm University. Frantzeska is also a member of the Research Council of the Law Faculty at Stockholm University and the chair of the Research Institute for Intellectual Property Rights and Market Rights. She is the editor-in-chief and founder of the Stockholm Intellectual Property Law Review, member of the board of the National Library of Sweden, and a member of the Expert Governmental Committee on Limitations to Copyright. She's also the author of several books and articles in the field of intellectual property as well as in regulatory rights. Frantzeska, we are truly honored to have you with us today to share your expertise on this important and evolving area. And before we begin, let me briefly explain the structure of today's session. We'll start with a presentation by Frantzeska, and then following the presentation, we'll move into a Q&A session where you'll have the opportunity to ask questions to Frantzeska. So please feel free to post your questions in the chat throughout the presentation. We'll collect them and address as many as possible during the Q&A. And for now, I would like to hand over to you, Frantzeska. Please feel free to share your screen with us.
Thank you so much, Vanessa, and thank you so much for this very kind invitation. It's my pleasure to be here with you today. We're going to talk about secondary publication rights. I'll just get rid of the screen here because I cannot see my presentation. So the issue of secondary publication rights has gradually entered central scene. We could agree about that. In the overall discussion on open science, it touches upon a very interesting aspect, namely giving the researchers the possibility to proceed with a secondary publication after a certain embargo period lapses, irrespective of what is stipulated in publication agreements between researchers and publishers. And let me see. And as I said previously, I've already mentioned the issue of secondary publication rights is part of the open science debate of the open science policy objective. And if we look into international and European open science initiatives, we could say that we can trace their origins to the open access movement in its turn. That was initially articulated in the declarations of Budapest in 2002, Berlin 2003, and Batseda 2003. We can also find origins of these discussions in the OECD's recommendations on enhancing access to and sharing of data and the guidelines on managing publicly funded research data that were also milestones in the open access discussion. In the same vein, the Plan S initiative has served as a significant development, reinforcing the central role of open access in the dissemination of research outputs. More recently, we have the UNESCO recommendations on open science that have emphasized the essential role of open access in realizing the human right to participate in scientific progress and benefit from its outcomes that has been articulated in Article 27.1 of the Universal Declaration of Human Rights. And UNESCO defines open science as an umbrella term encompassing a range of movements and practices aimed at making scientific knowledge freely accessible, available, and reusable for all. And of course, the European Union has also been very active in these discussions. The Commission first outlined its priorities when it comes to ensuring fair and equitable access to publicly funded research outputs in a recommendation from 2012 already. And building on this foundation, we've had policy documents in 2016, revisiting certain developments in the field of scientific publishing and assessing the actions that have been undertaken by European institutions to foster and accelerate this dissemination of scientific knowledge. And these actions, of course, have included the promotion of open access publications and open research data within the major EU research funding frameworks, such as the FP7, the Horizon 2020, and the current Horizon Europe programs. But I think when we talk about secondary publication rights, the most important initiatives actually taken by the Commission in order to support the objectives of ERA Action 2 was to commission this study that was to examine the impact of current EU and national copyright and data legislation on the accessibility and reusability of research data and publications. And this is a study that was published in 2024. You can see to the right the research centers and the universities that have contributed to the study. And it's quite a lengthy document that was the result of this research. I think it's over 1,200 pages long. It is a very interesting piece of work. It offers a detailed comparative analysis of key legislative instruments, including EU copyright directives and their national implementations. But it also looks into other data law related aspects that we find in the Open Data Directive, the Data Governance Act, the Data Act, the Digital Services Act, the Digital Markets Act, and the AI Act. And it also includes an evaluation of the European Open Science Cloud. And I think its approach is a very interesting one, because when we're talking about open science, when we talk about secondary publication rights, of course, we have to relate to copyright law, to intellectual property law, but nowadays we have a set of other legislative regulations and EU legislation that we need to take into account. And as you may understand, having to relate to all these different acts and directives provide a very complicated picture. So this study helps a lot in getting a helicopter view of what is applicable in this field. And the study identifies existing legal provisions that enable or facilitate access to and reuse of protected materials for research purposes, either directly through research-specific exceptions or indirectly through general exceptions with relevance to research. What I also appreciate in this study is the fact that it examines complementary legal mechanisms such as public domain rules and collective or extended collective licensing models that might in their turn support open access objectives. So based on this legal mapping and analysis, the study proposes a series of legislative and non-legislative policy recommendations that aim at aligning the EU copyright and data legal frameworks with the open science goals of the ERA agenda. And among the key provisions, the key recommendations in this study is actually the introduction of secondary publication rights, a right that would enable authors to make publicly funded research outputs available through open channels, regardless of initial publication terms. And why I find this work so interesting and why I discuss it in such a length is because although we have over 20 directives in the EU since the adoption of the Software Directive in 1991. We have several regulations related to copyright. We have over 150 preliminary rulings from the Court of Justice of the European Union that have somehow contributed to a convergence of national copyright systems. Despite all of that, we have a situation where copyright law still remains national in nature and exhibits still a certain degree of national fragmentation. And this legal heterogeneity has kind of significantly hindered the uniform implementation of open access policies across the member states of the Union, since these national divergences create some practical and legal obstacles to a coherent and effective implementation and effective enforcement. So within the European open access framework, this concept of secondary publication rights refer to a legal entitlement, I would say, to republish a scholarly work that has already been released under a primary publishing agreement that is typically concluded between the researcher and the publisher. And when such a right is properly designed, it would offer a crucial mechanism for researchers who do not opt for immediate gold open access, but seek to comply with institutional and further open access mandates through the more cost-effective green open access route to still make their works available on a broader basis. So, in fact, researchers often find themselves constrained between kind of the hammer of increasingly stringent open access obligations from the universities and the foundations that finance research, and on the other hand, of the standard and not really negotiable publishing contracts that restrict the publication sharing. In essence, what the secondary publication rights does is it grants authors the right to make their scientific publications openly and freely available after initial publication, subject to certain specified conditions. It could be, one could say that this constitutes some kind of a safeguard, a legal safeguard that ensures that open access remains achievable even in the face of restrictive publishing agreements. And actually, Germany was the first EU member state to adopt a legislative framework that provides for secondary publication rights with a legislation enacted in 2014, or legal provision enacted 2014. Germany has thus introduced an unwaivable right for authors to republish their work a certain period after the first publication, regardless of any prior contractual transfer of rights. And one could say that this German approach has provided for a solid, robust legal design that addresses the practical reality that many researchers, especially early career academics, have to face, meaning they have limited bargaining power. They seek to publish in high-impact journals. They are very often the ones to dictate rather rigid copyright terms. So this secondary publication right provides this critical tool for achieving the goals of open access. We will, in a moment, look into other national legislation. I mentioned Germany because it's such an early introduction of the secondary publication rights. I also have to say here, however, that talking to my colleagues, professors of intellectual property law in Germany that are really experts in the field, I've been informed that they have no knowledge of these legal provisions being applied. And you might wonder, okay, how would they have knowledge? There has not been a case, a court ruling related to this provision, at least as far as I am informed. And that, of course, doesn't have to mean that the provision is not used. It might be so that it is used broadly and it's so effective that no one dares to question it. But for us lawyers, somehow, when we see that there is no court ruling on a certain provision, we get the feeling that maybe the provision is not really put into practice. The same authors, or the majority of the authors that were involved in the drafting of the study that I presented just a few minutes ago, they have also published an article that you can find in this link here. And in the article, they have a very illustrative table I wanted to share with you. And here you see countries that have introduced secondary publication rights, when they have done that, and under which preconditions. So Germany is the first one, as you can see here. Then we have the Netherlands that followed in 2015 with the adoption of Article 25 FA of the Copyright Act. And the Dutch secondary publication right grants authors of short scientific works resulting from research funded at least partially by public sources the right to make their work publicly accessible free of charge. There is no threshold for the proportion of public funding required. I forgot to mention that for Germany, in order for the provision to be applied, you have to have research that was publicly funded for at least 50% of the total amount of the research. So in the Dutch provision, there is no threshold for this proportion of public funding, and there are no restrictions on the publication venue. And instead, actually, of a set embargo period, the regulation allows for a reasonable period after first publication. And this is to be determined on the case-to-case basis. And in general, one could say that the bigger the proportion of public funding that was applied for the specific project, the shorter the embargo period. So if you have like over, 50% public funded research, then you might expect an embargo period that is shorter than 6 months. But as I said, this is to be determined on a case-to-case basis. Then we have Austria introducing in 2015 a provision on secondary publication rights, and this provision entitles authors to make their scientific contributions publicly available 12 months after the initial publication. And there is a requirement that the work has appeared in a periodical with at least 2 annual issues, and that was based on research at least 50% publicly funded. However, the Austrian regulation excludes collective works, contributions to non-periodical publications, monographs, and annual reports. Moreover, the right is restricted to employees of publicly funded research institutions, thereby excluding privately funded researchers and non-academic staff. And this provision also applies only to the accepted manuscript for non-commercial uses and requires the author to cite the original place of publication. And like the German and Dutch provisions, the Austrian provision is also non-waivable by contract and applies retroactively. In 2016, France established its own version of this secondary publication right. It permits authors to make the digital version of their scientific work freely accessible, provided it was published in a periodical with at least 1 annual issuance, and the research was funded at least 50% by public sources, including the state, local authorities, public institutions, or EU national funding agencies. And unlike other national frameworks, the French secondary publication right is actually conditional. It only applies if the publisher has not already made the work freely available and requires the consent of all co-authors. The embargo periods are set at 6 months for publications in scientific, technological, and medical disciplines, and 12 months for the humanities and social sciences. And it is only the accepted manuscript version that is to be republished strictly for non-commercial purposes. And furthermore, the provision allows also for the free reuse of research data disclosed by the researcher of their institution, provided that no third-party rights or specific legal restrictions apply. And if we look into Belgium very briefly, it's in line with the other national models that I've mentioned. It has to concern research funded at least 50% by public funds and published in periodical journals, but it does not define any minimum publication frequency in order to apply. And authors are granted the right to make the accepted version freely accessible to the public, subject to an embargo period of 1 year for humanities and social sciences and 6 months for all other scientific disciplines. And even this Belgian provision requires that you disclose the original, the first publication. In the Belgian context, you have the embargo period that is fixed by default, but they might be shortened down through agreement between the author and the publisher or extended by royal decree, according to the law. There are no restrictions when it comes to reuse on the commercial or non-commercial nature of the reuse. And the provision is retroactive. It means it applies to works already published and contracts already signed. And it is also non-waivable. Any contractual clause that contradicts the statutory right is considered null and void. And then we have finally Bulgaria in 2024 introduced its version of the secondary publication right and in the Bulgarian Copyright and Related Rights Act. And in the Bulgaria, this provision, the author of a scientific work resulting from research funded fully or partially by public sources retains the right to make the work or parts of it publicly available on scientific or educational repositories, exclusively for non-commercial purposes. And notably, the Bulgarian provision allows the exercise of secondary publication rights immediately after the article has been accepted for publication. So there is no embargo period here. The only procedural requirement that applies here is that the author must in fact inform the publisher of their intention to exercise the right. And this is not something we see in the other national legislations, as far as I know. And in the same way as with other national implementations I've discussed, any contractual clause that seeks to limit or prevent the exercise of the right is rendered null and void. So as you have seen now with this short presentation of national secondary publication rights, it is obvious that we have different approaches, and these different approaches compare with the territorial nature of copyright. They significantly constrain the practical applicability and legal effectiveness of these rights. So in practice, national secondary publication rights are rarely put into practice, and they remain thus of limited significance because very often you have publishing contracts being signed between authors in one country and publishers in another. So you very often have cross-border transactions. So the lack of harmonization between member states that have implemented the secondary publication rights leads to inconsistent practices and expectations that I think are not very often fulfilled, both by academics and the publishing sector. So in order to have an effective secondary publication rights mechanism, one needs to have an EU-wide solution. We have to regulate this on an EU level. I think this is very important, and to have specified, harmonized conditions for all EU countries. Another issue that is, I think, important and sensitive is the legal status of secondary publication rights. And of course, here we also have the impact of different national legal traditions. I was a member of the expert committee for the revision of the Copyright Act with regards to limitations to copyright. And we discussed the introduction of secondary publication rights in the context of our work rather extensively, but we found that it was difficult to see secondary publication rights as an exceptional limitation in copyright. And the conclusion of the expert committee was that a secondary publication is more of a right than an exception, a limitation. This is, of course, legal technical stuff, but they play the role into how these provisions may be drafted in order to have a good implementation to be able to be used in practice and to align well with also EU copyright law, which is also equally important, of course. Finally, another way of seeing this is secondary publication as an obligation. That means that the researcher is not, how do you say, able to make use of this as a right, but is rather forced to make use of this. This is an obligation. If you have been, if your research falls under the provision, then you have to publish somewhere else. It's not a right that you have, but it's more something that you need to do. I will not go into that much into detail with regards to what I mentioned previously, the how do you say, cross-border transactions and the impact they have in this context and in the way secondary publication rights are used. But I would still like to say that researchers publish on an international level. I mean, I almost never publish in Sweden. So if you are a Swedish researcher where there is no secondary publication right and you sign a contract with a German publisher, what would then happen? Would I be able to apply or have the right to apply the secondary publication rights stipulated in the German legislation? My take on this subject is that it would be rather difficult. My guess to regulate output of research funded in Germany by German public funds. Of course, this is my interpretation, and there might be other ways to see to look into this, but I think it might be rather difficult to claim that I have the right to claim the application of the German secondary publication right. At the same time, we all know, all researchers that have published their works know that when we sign these contracts that we rarely read even, they most often provide for a competent court and applicable law clause. And usually the publisher chooses a legislation they are used to, they have chosen to apply to their business. I would have a difficult time seeing that a French publisher would agree in applying Swedish law and vice versa. So having a harmonized secondary publication right, I think, and I repeat it, I know, but I think it's kind of an essential aspect in the future regulation of this right. If we really want a right that is used in practice and that has an impact, a real impact. So, and when we develop this unified legislative framework that I hope will come at some point, there are some core design elements that I think should be carefully considered due to the fact that these have a potential impact on both researchers and academic publishers. And these, of course, include the types of scientific outputs to be covered by this right, the threshold and nature of public funding required to trigger the provision, the version of the manuscript to which the right applies, the length of the embargo period before the right becomes exercisable, and whether the right should be limited to non-commercial uses or applicable to any kind of use. And of course, from a legal perspective, there will be a complexity of implementation of a harmonized EU secondary publication right. And the more clear these elements are in the EU legislation, the easier the implementation will be. And of course, why do I think these are very important elements to consider and to answer on an EU level is because when I went through the different national secondary publication rights, I hope it was clear that you have kind of different requirements. There are variations as to what kinds of works fall under the secondary publication right. Some are very specific. It has to be articles and it has to be in periodicals published at least twice a year. Some others are more generous. The same goes with embargo. Some give different embargo periods depending on what kind of scientific background the author has, and some others apply the same embargo for all kinds of publications. And of course, equally important, what kind of uses are you allowed to do? Where can you republish and under which conditions? I think secondary publication rights are a great way of making scientific works available. I would not say that the situation we have now is optimal. I also find it is requires kind of difficult equations. As I mentioned previously, if it is an obligation for the researcher, it has a different impact than if it is a right for the researcher to republish. Because we have to accept that this discussion is not only about limiting the rights of publisher, but in some ways it could be interpreted as limiting the rights of authors. And as far as I understand, at least, the national experience has shown that the secondary publication rights are not really used as much as we would be interested in. And of course, Bulgaria is a country that introduced this in 2024, but we have Germany with a 10-year-old experience, where, as I mentioned previously, there is also very little experience of the use of this provision. I also think an important perspective in this discussion is academic career incitements. Researchers are interested in their future career. They publish because they want to advance in their careers, as well as because they want to share, of course, their research with the rest of the world. So I think it's important when we talk about open science, open access, and secondary publication rights to also look into career track requirements in academia and how open science and an open access publication is rewarded, because I don't know how it is in other countries and in other faculties, but in Sweden and in my faculty, open access or republishing of a published work is not really taken into consideration in any of the tenure requirements. I would also like to say on another note that although we don't have a secondary publication right in Sweden, both myself and a lot of my colleagues, we publish very often. We republish our work in SSRN. Also preprints are published there, and I haven't experienced any kind of reaction from the publishers. So I would say the publishers are quite generous, at least in my field of research. I am not sure how it is in other scientific fields. So there is some kind of open republishing already, even if it's done without a statutory right or without a clear-cut contractual agreement on the issue. I think I will stop there, and thank you so much for your attention and look forward to our discussion.
Thank you so much to you, Frantzeska, for that insightful presentation and for sharing your legal expertise on SPR with us. And yes, we have some few questions from the audience. Right now, I think I collected 3 of them. So the first one is, first of all, from them also, thank you. And the first question is, you argued for an EU-wide solution instead of national variations. Are you aware of any efforts by the EU to implement an EU-regulated SPR?
I think I don't have any insider information, but as far as I understand, the commissioning this study, which was very extensive, is related to the interest of the Commission in this question. And of course, there is an interest. It aligns very well with the open access, open science objectives of the EU. And I am not sure how close we are to this, but I know that for the Swedish part, the Swedish government is expecting something from the EU. It will facilitate for many member states, I think, to legislate on a national level if there is an EU initiative.
Thank you, Frantzeska. And another question that is about the applicable law. I guess that's why maybe the EU legislation would help here in this question, that I think it's very important practical question. And it's, can a publisher located in an SPR non-signatory country sue an author located in SPR country who distributes research, thus violating the contract clauses? And in that case, who protects the author's rights? The institution she works for a state agency?
Okay. First of all, it's not a completely clear-cut answer as to what is the applicable law, because if there is no choice of law and choice of competent court in the contract, then we have to look into principles of private international law. And I would say in that case that it would be easy to argue that the country of the author, where the author is situated, that's the legislation that would be applicable. And if you are in a country with an SPR, a secondary publication right, then I would say that would precede, that would be the applicable law, and thus you would have the right to republish. Then the publisher would not have any lack in suing you, because what you're sued on is copyright infringement, really, because you have transferred the rights and then you make further use of them. But if there is a choice of law clause in the contract, that could complicate things, because the question is, what happens then? In the example where you have an author situated in a country, let's say German author, and a publisher, a Swedish publisher. Sweden has no secondary publication right. The contract, the choice of law clause states that it is Swedish law that will apply. I would say that this clause would not supersede the German provision of secondary publication right. That would mean that the author would be able to republish. So it will depend, right? It will depend on if there is a choice of law clause in the contract or not, and which jurisdiction you end up with. But if you end up with a law that provides for secondary publication rights and that is applicable in the specific case, then I would say the author will have the right to republish without, I mean, the publisher can always sue if they want, but they will not have any lack, I would say. But that's my kind of interpretation.
Thank you, Frantzeska. And another one is, what happens with articles with multiple authors? What determines whether SPRs are applicable, and the location of the first author?
A good question. Now I don't remember which legislation it is. Maybe it's the Bulgarian. I'm not sure. In some national legislations, in order to republish, you need the authorization of all authors, co-authors. In most of them, it's you as an author, even if there are 10 more co-authors, you have the right to republish anyway. With the question of which legislation, I would say depending on which author makes use of the provision. So when you have at least one author that comes from an SPR country, then you could republish. That's what I would claim.
Thank you. And we have another question. Are there any available data on how often authors from countries with SPR legislation have actually exercised that right?
That's a very good question. The study that I mentioned includes or is also partly based on interviews with researchers. You can check the study for more information on that. The conclusion was that this is not really very often used. There is an uncertainty by researchers on the exact interpretation, implementation, use of these provisions. And I will go back to what I said about academic career paths and stuff. You are not interested in risking a conflict with a publisher if you and you will not read or negotiate the publishing contract. So most researchers would not even think of applying the secondary publication right. At the same time, as I said, we publish all the time at SSRN without no one reacting, but I don't think anyone does it bearing in mind the secondary publication rights provisions in their national legislation. So it's difficult kind of to give black and white answers, also because we have no case law on these provisions, as far as I know, and it's difficult to say how they would be implemented and interpreted in practice. But the conclusion from the study was at least that the secondary publication rights provisions in national legislation are rather unclear and not really that used in practice.
Thank you so much, Frantzeska, for sharing your expertise and details and yes, with us today. And we are truly grateful for your time today. So
thank you so much, Vanessa. Thank you.
And a big thank you also to everyone who joined us today. And we truly value all of your time and the engaging questions you brought to the discussion. And before we say goodbye, I'm also pleased to announce our next IP4OS webinar, which will take place on June 12th at also 1 p.m. And we'll be joined by Professor Richard Gold, who will speak on the exciting topic, Open Science as IP Strategy. And we will share the registration link in the chat. And so we would be happy if you sign up and reshare the link with your community. And once again, thank you all for your time and attention, and we hope to see you next month. And until then, have a great day and goodbye.